Start. Para. This appeal and the revision petition has been filed by the plaintiff in OS number 433 of 1926 on the file of the District Munsif of Rajmundry. The plaint was for a declaration that the release deed dated 23rd March 1924, executed by the plaintiff and some other defendants in favor of defendant number 1, was not valid in law but fraudulent and void, and that it could not bind the plaintiff for dissolution of partnership and for other consequential reliefs. The valuation put in the plaint was a sum of rupees 100 and court fee stamp of the value of rupees 114 was affixed to the plaint. An objection taken by the defendant, the court under section 12 of the Court Fees Act inquired into the question of the proper valuation of the plaint and came to be conclusion that the valuation of rupees 100 mentioned by the plaintiff was the correct valuation. The trial court came to the conclusion that the valuation should be rupees 56,919 in addition to another sum of rupees 2,318. It accordingly passed the following order: before the suit is returned for presentation to proper court, the plaintiff will have to pay the court fee on rupees 56,919 mentioned above plus 2,318. The amount of consideration paid for the release deed and gave time to the plaintiff to comply with the said order. The plaintiff not having complied with the said order, the court by an order of later date rejected the plaint. The directed plaintiff to pay the defendant's cost on the basis of the valuation in the plaint. The plaintiff preferred an appeal to the District Court of Rajmundry. The learned district judge agreed substantially with the decision of the District Munsif on the question of the proper valuation of the plaint. The learned district judge were thought that instead of the plaintiff having to value the plaint and pay court fee on the sum of rupees 56,919 as mentioned in the trial court's order, it was enough for the plaintiff to value his plaint as 5/6 of the said amount, being the shares of the plaintiff and the other defendants who executed the release deed in question in the partnership. He accordingly modified the trial court's order in that respect and directed that the case should go back to the District Munsif in order that the District Munsif might call upon the plaintiff to pay court fee calculated on that sum within a reasonable time. Against that order, the plaintiff has preferred the present civil miscellaneous appeal, and in the alternative, he has also filed a civil revision petition. On his behalf, the learned advocate argued that, having regard to the allegations in the plaint as a whole, the plaint should be taken to be simply one for the taking of accounts and not to set aside or cancel a document within the meaning of Section 7 Court Fees Act, as recently amended. The learned advocate took us through the substantial portions of the land submitted that must be taken to be the oral nature of the plaint. We are unable to agree with him in that contention. The first prayer asked for in the plaint makes it clear that the plaintiff want a declaration that the release deed is not valid in law, that it is fraudulent and void, and that it is not binding on the plaintiff. With this prayer before us, it is impossible to dispute the finding of the lower courts, and we accordingly accept the finding of the lower appellate court that the correct valuation of the plaint is the amount mentioned by the lower appellate court. Stop.